Your Free to Go is sponsored by Milburn Men's Clothing, where top athletes shop for sharp, tailored style. And whether Mark and I are in the studio or the courtroom, Milburn dresses us for success. Mention YFTG and get 10% off at Milburn Men's Clothing, which has been providing the finest in men's clothing and suits since 1946. Call 651-645-2922 or visit www.milburn.com. Welcome back, everybody, to your favorite podcast, You're Free to Go. I'm in the studio today in Boca Raton at Podcast Junkies, and Mark is out in LA, and he's in his home office, which sometimes looks more like a music studio than a home office, right, with all his guitars in there. Welcome, Mark. How's everything out there going?
Excellent. Weather's good. It's sort of like South Florida right now.
Yeah, we might be a little colder than you out in LA, but you have the perfect weather always. So maybe we'll start moving our show out there so I can enjoy that weather. Mark, if you just give me a second, I want to share with our fans what's in store over the next several episodes. You know, we don't know when people are listening to this podcast, but as of today's date, as we record today, we've dropped 24 episodes. And when you combined YouTube, Spotify, Apple, TikTok, Instagram, all the platforms out there that you can listen to us on, we've had well over 200,000 listeners. So things are going really well for us. And our listeners know that our episodes cover one of three topics. They're either our crazy ass cases, the cases that Mark and I have handled ourselves that we talk about, or they're legal topics like jury selection or cooperation. And finally, one of the topics we do in episodes is when we have our own clients on as guests. Well, You're Free to Go today is growing and evolving because we're really excited to start a 4-part series with guests who are not clients. They're not former clients of our law firm. So this is a really exciting time to start these 4 non-client guest episodes. And today is a really good one. I'm going to tell you what the 4 are going to be. But today starts with the topic of police misconduct and abuse of force. That'll be followed by our next episode with a highly respected New Jersey, New York criminal defense attorney. The third one is going to be a retired police officer turned private investigator. So you hear a lot of great stories from behind the scenes in these criminal investigations. And then the fourth, to round off our 4-part series, is a public relations expert who has public relations perspective from the criminal prosecution side as well as the criminal defense side. So Mark and I are really excited about these 4 upcoming episodes. And today, we're really honored and excited to have Oscar Seiger with us, who's an attorney, and his practice focuses on probably the most prominent and controversial topic in the news over the past several years, or at least one of the most controversial topics in the news, and that's police misconduct, abuse of force, government misconduct, basically that entire genre of abuse of force and so forth. And we're really excited to have Oscar with us. So without further ado, I'd like to welcome Attorney Oscar Seiger to the podcast studio.
Good afternoon, everybody. It's my honor to be here, and it's especially an honor to be here with Guy and Mark, 2 excellent criminal defense attorneys. And I'm eager to hopefully enlighten people about what's going on today and what our rights are vis-a-vis the police and the government in general.
Well, that's exactly on point because we like to talk about our experiences, but we also use this podcast as a tool to educate our listeners. And we get calls all the time from someone who actually, Ben once commented, our engineer Ben, who all our fans know Ben because he'll jump in occasionally with questions. But Ben, we had a topic about jury selection. And he came in and he said, you know what, I'm so glad it was live on our podcast that you just educated me on that because I've been afraid to get subpoenaed for jury. Didn't know what to expect. I was a little nervous about it. So we do take this opportunity to educate our fans as well. So I think maybe if you can want to share a little bit about how you got into law and kind of gravitated toward this specialty in your practice, and then maybe share a couple stories with us and of your own experiences, and then we can expand into maybe some things going along or in the country, like in particular Minneapolis, Minnesota right now. So we'll kind of give you the opportunity just to take the mic and run with it, and Mark and I will jump in and just have a lovely conversation.
Well, thank you. First, I became an attorney because I wanted to help people, and I always loved reading. Now, how I got into this particular field of police misconduct required me to draw on two childhood traits of mine. Number one, questioning authority, and number two, having a sense of justice and injustice. Now, this is perhaps lighthearted, but since I was the class clown and a little bit mischievous, I always seemed to attract the notice of authority. On a serious note, so this happened to me about 12th grade, went away on some kind of an organized weekend, and I have to preface this, falsely accused of being involved with marijuana. And back then, it was a serious charge. I was totally innocent. I had two administrators berating me, and that taught me the need for standing up for one's rights when one is perfectly innocent of the charges.
Wow, at a young age, that's cool.
Young
Very
age.
cool. And nowadays, they would have taken the marijuana and smoked it themselves and said, "Have a good afternoon, young boy."
And
Like
the
it's
government
totally
would have
legal.
sold it and
Yeah,
taxed it.
right.
So yes,
Yeah,
it's a
so-
sea change.
Yeah.
So, and then starting about 30 years ago, I was a young lawyer and I was asked to represent a municipality in Miami-Dade County. I won't mention which. And in coming across that, I was tasked with representing the police in claims against, and generally there's two types of actions, two types of unwarranted conduct that the police inflict on us. One is arresting us without cause, and number two, using too much force even when an arrest or detention might be justified and appropriate.
Do they seem to be equal? Do you see as much of one as the other, or do you see more unlawful arrests or more abuse, or pretty?
That's a great question. I would say probably more false arrest. And then, guys, sometimes the question of whether too much force is used or not all depends on the basis for the stop, detention, or arrest. But I see false arrest arise more because often false arrest is the tool that's used to snare innocent bystanders to a crime.
Right.
There certainly is a lot of very violent conduct from police. So there is a great deal of brutality.
As well. Sure.
Well, that seems to be pretty timely right now because we see, these protests and we see even people who are watching and observing and are actually videoing on their phone what's going on right in front of them. The police sometimes are threatening them or telling them to stop doing that. I mean, doesn't a person have a right to film a police officer who may be beating someone?
I'm grateful for that question. And the answer is, I'll give it an equivocal but hearty yes. In general, we have an absolute right to record unconstitutional conduct. The only limitation is if somehow our act of recording or witnessing somehow interferes with the lawful duties of a police. About a decade ago, and this happened in Broward County, I represented an individual who was filming with his cell phone an act of brutality instigated on somebody in the neighborhood. After the police realized that they were being recorded with a cell phone, one of the officers walked over, and you see this on my ultimate client's cell phone, police officers walking across a very large street. His image is larger and larger as he approaches the cell phone, and all of a sudden the cell phone goes blank. So in this instance, the officer, without justification, confiscated the phone and ultimately destroyed it. The contention being that this individual was interfering with the arrest. He was not. He was geographically far away.
Mm-hmm. Is that an obstruction of justice or just, I guess?
Their contention, and thank you for raising that, was that he interfered, obstructed with the arrest, but without violence. And I believe that's Florida Statute A43.02. But this was, in my opinion, nonsense. And it showed my client was the citizen. Forget about him being my client. The citizen was so far away that he was not at all interfering. and we were able to obtain a satisfactory amount for him in a negotiated settlement. But to Mark's point, yes, absolutely. And I'm a big proponent of people standing at a far enough distance, both for their safety, but also to not be snared with this idea that they're interfering, and recording government wrong, especially in an age of body cam, which body cam can be selectively turned off and on.
Right.
But
Which that's good. Criminal defense lawyers will just, on cross-examination, will have a field day with that. Your body cam was working, right? And you chose not to turn it on, or allegedly it's been broken, but it's been broken for 3 months. And did you ever report it broken? And yeah, there's definitely a lot of selective on the law enforcement side of turning it on versus turning it off, which is very frustrating because in my experience, body cam is often the best evidence for defending our clients.
What about, can I just interrupt for a second? So a follow-up to the question about the ability to film is, what about that same citizen standing on the sidelines and yelling, "You're hurting that man, you're killing that man, you're choking that man," like in the George Floyd, or I forget the other one where the person was being choked.
Eric Garner.
Right, Eric Gardner, right. What about that type of situation? Can you yell from the sidelines?
I'm grateful you asked. This comes under our free speech rights, First Amendment, absolutely. And there's a case right in point, and I believe it's City of Houston versus Hill or other way around. And one of the gems from that opinion, and it's a United States Supreme Court opinion, is that what differentiates us, or supposedly what differentiates us from a police state, is that we do have the right to question law enforcement as they're carrying on their official duty. Like many people, I was moved by the comments that the bystanders were making in the George Floyd scenario. Yes, and in Florida, there's case law that goes on to say we have the right to question the basis of the arrest. In fact, we have the right to say the F word to law enforcement. It may not be wise to do so
Right.
in some instances.
Not a good idea.
Because you're going to guarantee yourself an arrest. But absolutely, Mark, and I think it's a right that we have to assert, or if not, that right is going to be diluted.
And when you talk about these cases so far, you've referenced Florida, and there's often nuances from state to state. But when you reference Florida, is it generally going to be the same across the country, or are there vast differences on the laws you're talking about?
Certainly. It's probably going to be uniform across the country as to what conduct will result in a deprivation of civil rights and concomitantly a civil claim.
Right.
What might be different among the states is different notice requirements. Perhaps some states like Florida have a statutory cap on damages. Mm-hmm. But our national constitution confers on us the rights, and this is across the country, free speech, the right to be free from excessive force and unreasonable seizure, and the right to be free from an arrest not occasioned either by warrant or by probable cause across the country, across the nation, 50 states.
Good, because the beauty of the podcast is we're worldwide. It's pretty cool, right? The technology to that. But there could be someone in Paris listening to us right now. But any state within the United States for sure is very common. So I'm glad you pointed that out for us. Before we get off of the topic of videoing, if someone were to bump into you, you're talking in the middle of a bar, at a restaurant, wherever, and they say, well, hey, Oscar, what are my rights if I'm pulled over for speeding or, filming? What would be your, for example, with DUIs, a lot of kids come to me and say, well, how much can I drink and drive? And my response is always, if you have 1 ounce of alcohol, you do not drink. You do not drive. Sorry. Obviously, if you're under 21, you shouldn't have that 1 ounce. But realistically, knowing that minors will drink, my answer is always, if you taste a sip of alcohol, you do not drive. So what kind of advice if someone asked you, hey, really, what can I film or not? What would be your staple answer to that person?
That's a great question. And I've seen inadvisable acts of filming, and that is where somebody decides to narrate the citizen rather than filming, and in addition to the narrating, manipulates the phone so as to actually interfere with the arrest.
Okay. Yeah.
My suggestion is to let the camera do the talking. Somewhere put the cell phone where it's going to get a good angle between the citizen and police and do nothing more. I would preface my comments by saying, officer, I'm exercising my right to film you. I will abide by your commands.
That's good. Perfect. Great advice. That's exactly what I was wanting to hear. How does
And what if the officer then says, "Well, I'm not going to allow you to film"?
Try
Of
to
course,
have that
he
cell
can't by
phone
law, but he's going to do it.
understood. The cell phone will do the talking. Leave the cell phone footage on. That's a great judgment call whether or not one should say, well, I have the constitutional right to film, which we do. Film, if that, in my view, if that officer, with nothing more than what you've described in your scenario, takes the phone, then he's already guilty of a Fifth Amendment taking of property without due process. And I certainly think the recording of the act of confiscating the phone can lead in skilled hands such as yourself, Mark, or Guy, to some type of suppression motion or some type of adverse inference to be drawn against law enforcement.
Yeah, I mean, obviously the argument is if you didn't want it filmed, it means you were going to do something that you shouldn't have done.
Agreed, and we turn back to body cam. Guy makes an excellent point. These cameras can be turned off and on at will, and sometimes in violation of the statute. I think most of us would be surprised, at least I am, I'm editorializing, that the police have so much discretion in turning off and on their camera. I understand some things when going into a private home or business, but I have seen things where the camera ends just before the exercise of physical force by the cops begins. What more can you say about that?
Right.
And so I think our best friends are things like cell phone. And I have a case now where, interesting enough, because the police didn't have the body cam, and this apparently is the policy of the city of Aventura, their law enforcement doesn't have a body cam. And again, I'm technically inept, so I'm learning as I go along. The Ring cameras, in this instance, the act of police misconduct is partially captured on the Ring camera
Oh, interesting. It was by the front door?
by the front door.
right?
Wow. By the way, do you know why the city of Aventura has that policy of no body cams?
A great question. I have a public records request out there, and I'm waiting to understand why that policy was implemented. Because as I understand it, that if a municipality accepts certain state funds, they have to have a body cam. So I'm still waiting to learn that one. This is, again, editorializing.
Right.
If these police officers involved in this particular instance wore body cams, that would be my best case. I would just simply turn on the projector, and that would be my case in chief.
Yeah, and the police need to realize now turning off the body cam is not a good idea because there's cameras everywhere. You get a good private investigator on a case, they're going to find the Ring cam that you just referenced. They're going to find a traffic light with a camera on it. Maybe that one doesn't have audio. Ring cams, most of them, if you pay for the subscription, has audio and video. But there's cameras everywhere nowadays. And as you were talking earlier, you gave an example of a case where there was an innocent bystander videoing. So nowadays, very often, when there's an incident going down, if there's anyone within 100 feet, they're pulling out their cell phones and recording it. So it really makes no sense. It really backfires on officers when they turn those cameras off.
I would think that it actually helps the officer in most cases because with the body cam, you get the view from the officer's perspective.
Right.
So if there is a threat of force to the officer, the best view of that is from the body cam, you would think, because it's the officer's subjective belief of what is going on. And so, I mean, if I was a police officer, I would keep my body cam on and not even risk shutting it off and opening to cross-examination. And of course, there could be situations where there's a crowd around and the crowd might have a different view. They may be anti-police and they may be making accusations against the police officer. So I think it protects the police officer and protects the public. It should be universal. And I'm shocked to hear that Aventura doesn't have it.
I'm going to switch hats for a second to my old days as a prosecutor, and what cops would often say is that it doesn't actually come through on the body cameras. So, for example, they're hearing slurred speech, but maybe on the body cam, you don't actually hear the speech as slurred, or that they are seeing, bloodshot eyes, and you can't really see that as well on the camera. So cops, prosecutors, we used to get concerned about that with officers because we knew the defense was going to say, hey, watch this camera. The cops will often, let me, again, with my prosecutor hat on, the police and the prosecutor will have a gut instinct that this person really, the defendant, really did what he's accused of. And sometimes maybe the evidence isn't overwhelming or it's not beyond a reasonable doubt, but they know in their heart of hearts that this person's guilty of it, and then they start to embellish. They say, well, and DUIs are the easiest ones to use an example. They'll say the defendant was swaying 2 degrees right to left, and then the defense will say, well, look at the pole behind them. There's a tree. There's a palm tree perfectly vertical, and you don't see any swaying there. So sometimes prosecutors and police, again, with my prosecutor hat on, they get frustrated because they know the person's guilty. They know it, but they don't have the evidence, so they embellish some. And that's a time where they don't like those body cameras, Mark, because they do show that they may have embellished. And then, of course, defense lawyers like us will exploit that on cross-examination. And that's how we get not guilty verdicts,
Oscar, I'm real curious as to your view of what happened in Minneapolis. I know that it does require some opinion, and these aren't facts. But what was interesting about that situation is we do have a pretty clear video taken by bystanders of what happened in the seconds before Ms. Good was shot, and where the police officers, where the ICE agents, that is, were situated. And I know, a lot of people have the opinion that there was really no threat or imminent danger to the ICE agent. What do you say about this?
Well, I'm going to be lawyer-like. Can I ask you to walk me through, say, the preceding events or questions that you have that you find salient?
Well, particularly just, this was a case, obviously, where people, bystanders, at least one bystander, I think it was several, took some clear video of what happened. Granted, it was from a certain angle. And that so far seems to be the public evidence. I don't know if there's any other evidence that's part of an investigation. But in your opinion, does it reflect an abuse of force or use of excessive force, deadly force in this situation without justification?
In my opinion, yes. I find this to be a blatant use of deadly force. I'll preface my opinion by citing to a United States Supreme Court case that defined the factors that go into determining whether too much force was used during an otherwise lawful arrest. And what I find particularly egregious, and this is why I was asking you what you saw, what you were looking at before the car and the ICE agent had some contact. But in my opinion, all I am seeing so far is vigorous, protected, free speech and conduct questioning why the police officer, why the ICE agents, what they were doing in that area. In the instance of Ms. Good, there's nothing that has made the public record that shows to me that she interfered with what the officers were doing. Now, words alone, in my view, don't constitute interference unless it's along the lines of egging on somebody else to do violence to the police officers. In my view, we're allowed to mock law enforcement. We're allowed to question what they're doing, and we're allowed to criticize. So one of the factors in Graham versus Connor, this case on use of excessive force, is the severity of the crime at issue. And I see this unfortunate victim as doing nothing more up to the point of the encounter than she must have been questioning. Now we get to the circumstance of the car and the ICE agent making some contact. He used deadly force, in fact, the deadliest of force. And so in order for that to have been justified, and here's where this question turns, what threat to him was objectively presented to him? What threat to third parties was presented, objective threat? In my opinion, whatever threat there was minimal. She had expressed no intention of harming law enforcement. The act with the car was ambiguous. I've had cases where the facts show that the citizen intended to strike an officer with his car. That's not at all clear to me here. And so after we look at the severity of the crime, which I think was minimal or none here, we look at the threat to the bystanders. This wasn't a woman who was on a crime spree and happened to have gotten caught at that particular intersection, nor had she threatened third parties. If police had wanted to detain her, they had enough identification on her that they could have captured her shortly after she had departed the scene. She didn't flee in an aggressive manner, so in my opinion, the act of firing and again shooting at the driver, because that's what police are trained to do. They're not trained to shoot at the car or shoot out at the wheels. They're trained to try to kill the driver. And I just think this is beyond unfortunate. Again, politics aside, in my view, what needs to have been done, quite frankly, is a DOJ investigation of the ICE agent.
So you just said something toward the end of that answer about officers are trained to shoot the person, the suspect. When you evaluate these cases, how do you factor in training and experience of officers? Let's say it was a rookie versus an officer who's been on duty for 25 years, has every training there is. Is there an analysis that goes into whether this?
There is an analysis of the training. In fact, there's a body of law that allows us to hold the governmental employing unit liable under a theory of failure to train when the need for the training is obvious. As I understand your question, though, I don't, if you will, give the rookie a free bite and compare him to a 25-year-old officer. My take is if the municipality or county is putting that rookie in a position where he or she has a gun, then they're bound by the same dictates as the 25 to 30-year-old officer.
Right, because a suspect has the right to hold law enforcement up to the same standard, whether they're on the force for a year or for 25 years. Like, we have that right. It's our constitutional right, and we have the right to hold them up to the highest standard, no matter how much experience they have. Mark, I think we're time for maybe a middle of the session break for our one of our sponsors. What do you think?
Absolutely. Let's do it.
All right, Ben, you want to throw in a sponsor? Thanks. You're Free to Go is sponsored by Lang Realty, South Florida's premier residential real estate broker. Whether you're buying, selling, or renting a home or condo, Lang's experienced realtors are standing by ready to help you. Contact one of Lang's top realtors today at 561-703-2427. All right, here we are back for continued with Oscar, who I know all you guys are loving this episode. Highly educational and some really cool personal experiences as an attorney handling cases like this. Anything else that pops in your mind that you think our listeners would enjoy hearing about on a particular
Can I ask another question, a follow-up question?
Your questions are great. Thank you.
Okay. Drawing back to the good situation in Minneapolis and just a general question. Is it clear that just simply fleeing the scene without posing a threat to the officer or bystanders does not justify deadly force?
In my opinion, and the way I read the case law, yes, simply fleeing. And as an example, a fleeing misdemeanant, right? A petty shoplifter. I don't think any of us want to live in a society where police are allowed to shoot a shoplifter who happens to try to run away. So in my understanding of the case law, deadly force requires that a serious crime has been committed and that there is a threat to the public at large or other officers.
You know, here in LA, as you know, you turn on the news at night and it becomes a form of entertainment. We watch almost nightly, car chases where the police are chasing after a car. And what's very interesting is they can last 10, 15, 20 minutes, and you have the helicopters following with the searchlights. And the police, to their credit here, are very careful, and they don't use any deadly force. Certainly, they don't want to expose other people, who are bystanders to a car that's gone wild and lose control. And they throw down these obstacles sometimes that blow out the tires. But it's pretty clear here that if you're just simply fleeing, you don't get shot.
Yeah.
So I would assume that's the case, or should be the case everywhere.
I want to just a little side note on this topic of fleeing. So, and this is Florida law that I'll talk about. Now, a lot of people don't understand when, let's say you decide you're going to enter a plea to a case, you're not going to go to trial. If you're going to go to trial, you're saying, I'm not guilty. That's the plea you're entering, not guilty, and let the jury decide. But if you resolve it by a negotiated settlement, you enter a plea, and I say the front side, there's two sides, the front side and back side. The front side is the defendant saying, Your Honor, I'm guilty, or I'm admitting no contest. And the back side of that negotiated settlement is the judge making a decision whether to convict you or not convict you. A lot of people think if I admit guilt or no contest that I'm automatically convicted. Well, the judge actually has discretion on the back side of this plea in Florida to say I'm convicting you, which is called adjudication of guilt, or I'm not going to convict you, called a withhold of adjudication. Again, we're just speaking to Florida. Our legislators, our elected officials in Tallahassee, the capital of Florida, decided there's 3 cases where they take the discretion away from the judge and they must convict you. One is murder, so you can't get a withhold of the conviction on murder. That makes sense, right? The other, believe it or not, is DUI. And the third is fleeing. A judge must convict you in Florida if you admit guilt or no contest to fleeing. And the reason, it's more of a public policy argument by our elected officials, where they say, that you're putting yourself, law enforcement, and the public in harm's way if you flee. We think it's so important that whether it's a wrongful arrest or not, that you stay and do not flee, because the public, the public at large could be as well as yourself or law enforcement. So it's kind of interesting. It's just a little side note that the legislators, our elected officials, have prioritized or made it that important that fleeing, you must be convicted if you admit guilt to it. And it also comes with a 1-year driver's license suspension and so forth. But anyway, it's
Stay put. Stay put, huh?
Yeah, just stay put and then hire a good lawyer like us, and we'll work things out for you. And Oscar will help out too. You've mentioned a little bit on the civil side. So what is the cause of action? Are these criminal cases? When you go to court, are you in criminal court or are you in civil court? And if you're in civil court or criminal court, are there money damages that you can get for your clients?
Yes, there are money damages, and I'm always in civil court where, to the non-lawyers, that's where we sue over money. Gentlemen such as Guy and Mark save our liberty, which is more valuable.
Well, it's funny you say that because a friend of mine who's a judge was on divorce court for 5 years and criminal court for 5 years, said they never got a threat on criminal court, but when they were on divorce court where it was about money, they got threats all the time.
Oh, yeah, we've had situations where lawyers in depositions in divorce cases have been killed.
Yep.
Been shot by a angry husband, angry wife, or somebody else. In fact, that's why we say criminal lawyers see the worst people at their best, and divorce lawyers see the best people at their worst.
But no, but you're right though. When we talk with our clients on the criminal side, we say if there's civil side to it, we say we need to be the captain of this litigation because you need to put your liberty, your freedom first ahead of your wallet. So you are correct.
And thank you. I wanted to touch on something you said. So generally, my involvement, while I might meet and start the act of representing somebody as soon as possible, say after the arrest or the police-citizen encounter, generally I'm going to wait, subject to statute of limitations, until after the criminal proceedings are over.
Because you have to prevail on the merits in the criminal proceeding, right?
Well, I can live with a finding of guilt to some offenses, but some offenses, a plea or a finding of guilt are fatal. For example, if somebody pleads guilty to an underlying offense, generally that's going to cut the legs out of any false arrest, false imprisonment claim. And perhaps this is self-evident, but if somebody pleads guilty to battery on a law enforcement officer, then any claim for excessive force is foreclosed and will be met with by a sanctions motion, either by the government lawyers or by the judge. So I generally advise clients while they're going through, this is actually a real-world scenario where they're facing the dilemma of a very favorable negotiated plea or going to trial. I'm often in a situation where I'm conferring with criminal defense and the mutual client and saying, look, your liberty to me is much more valuable than the amount of dollars I'm going to get you. And oftentimes it's come down to where somebody makes a decision to forego a civil claim in order to avoid jail time.
And sometimes the prosecutors actually insist on that you forego. They say, you basically to dismiss the civil claim you have, or you agree to hold the police harmless.
That's outrageous. I understand that happens, but that is an abuse, and I wonder if...
It's extortion. It's legal extortion.
It's legal extortion, and I wonder, can something like that be set aside on grounds of duress? I can't say I've ever tried it, but what a horrible Hobson's choice to make, because now you're depriving people of two potential rights.
Right.
But, and then just to finish up, as far as money damages, what we look at is the amount of the physical injury, the amount of impact to a person's life caused by the injury, lost wages, expense of hospitalization. Those are things that factor into how we evaluate a personal injury case stemming from police misconduct.
Right. Well, I would say 90% of my clients will tell me that the cops put the handcuffs on too tight, and now they have numbness in their fingers. And I actually had an older gentleman the other day, and they put him on so tight he started bleeding. I think he was on some blood. I mean, when I say older, he was in his 80s, and I think he was on some blood thinner. So that was part of the reason he started to bleed so easily. But I'm telling you, probably 90% probably almost 100% clients always say they put them on so tight. And have you seen that yet, where there's like permanent some type of numbness in their fingers to the point where there is a claim, or is that something that's never going to lead to a case?
Well, that's interesting. In our 11th Circuit, there is a body of case law that holds mere tight handcuffings with some incidental injury doesn't give rise to cause of action.
Right.
To your point, I have something very similar where my then 89-year-old client is arrested on the charge of damaging a camera in his condominium, Common Elements, and there's body cam where my client is asking the officer, loosen the cuffs. This officer, and I take a dim view, responded by saying they're not meant for comfort. Meanwhile, due to his age and an existing skin condition, he's bleeding out.
Wow. Oh.
So there are, though, causes of action when, during the handcuffing process, something goes awry, like a spiral fracture to the wrist or a dislocation of the shoulder. And those cases are, to use the legal word, actionable, meaning we have a right to go to court for them. And I do see where there are officers who are sadistic and purposely put the cuffs on too tight.
Well, you mentioned the shoulder. Reminded me of, I've had a number of clients over the years who said that they told the officer they have really a bad shoulder. They had surgery on a shoulder. Could they cuff them in the front instead of in the back? And they every time they say they never accommodated me, they always blame it on a policy, that they have some type of corporate policy that they can't cuff in the front. So I don't really understand why they have a corporate policy that you can't cuff in the front to help someone with bad shoulders, because they're just as restricted whether they're in the handcuffs are on the front or back. But what about when you talk about money damages? I think our listeners probably have heard the term sovereign immunity and so forth. So are there caps? Are you allowed to sue the police always? Are there times when you can sue them and times when you cannot sue them? And if you can, or is there a limit as to how much you can ask for in your lawsuits?
The answer to all your questions is yes, sort of. So to go back, when we talk about excessive force, for example, the law allows officers to use force, but the force has to be appropriate to the circumstances presented to that officer. So in Florida, for example, there are theories against the governmental employer, usually the county or a municipality. And in those instances where we're just suing under the state law, the most somebody can recover is $200,000. Of course, that gets divided up with the lawyers to some extent. Many states, not all, have that kind of statutory cap. However, when we are suing for a constitutional violation, which is somewhat undifferentiated, is a common law violation plus, then the federal law steps in, and as to the individual defendant officers, there is no statutory cap. And as to the government, who is usually protected by the cap, then that cap no longer protects them, and there is no limit on damages. Also, to a citizen who prevails against law enforcement in a civil rights case, there is generally an award of attorney fees to the victim of the police misconduct. So to go back, in order to sue the police, there has to be more force than what's appropriate under the circumstances, and usually one needs an expert to enlighten the jury about that, or when the arrest was unjustified.
Right. So a lot of it is focused on the police, and what I also think about is when a prosecutor, the office of the state attorney, the office of the district attorney, the U.S. attorney's office, what if they misrepresent? They hide evidence. There are certainly cases that Mark and I have handled, and lots of lawyers have handled, whether it was intentional or not intentional. There have been times during the litigation where the defense finds out that the government represented this evidence doesn't exist, and we find out that it did exist.
Brady.
Or yes. So I always think about the Duke lacrosse case from, I don't know, probably
Michael Nifong,
Yeah,
2006, yeah.
right. And
Outrage.
yeah, so yeah, if you have any thoughts on that, like where can they be held accountable? When I was a prosecutor, they always said to me that you can never be sued. Don't worry about it. Just do your job. As long as you don't break the law, you're fine. No one can sue you for anything. Just be a zealous advocate, for the government.
I would certainly like to brush up my knowledge of prosecutorial immunity. I have a general understanding that for almost anything that a prosecutor can do, as long as it's attached to his or her position, they're immune. What my and the theory being, well, number one, we don't want to chill prosecutors. I think that's an outrageous reason given. And then we're told, well, if a prosecutor does, for example, what Nifong did, which was omit favorable evidence and almost conjure up evidence, then we're told, well, there's all sorts of discipline, such as the bar discipline or perhaps even a criminal offense. But I don't remember reading a case where a prosecutor ever went to jail for tampering with evidence. Have you ever had anything like that?
Well, I do think it was the DA in North Carolina, Nifong. I think he did go to jail. I'm pretty sure he did. I know he lost his bar license. And for our listeners and fans out there who may not be familiar with the case, highly recommend, if you ever want to see people that were wrongfully accused, unfortunately had the resources to hire really good lawyers.
A smile comes to my face, exactly.
Yeah, to prove that. It's the Duke Lacrosse. That's all you have to do is Google Duke Lacrosse team, and you'll see it. There was an allegation of that the team was having a party at one of the team players' home. There were a couple of ladies over there, and there was an allegation of rape. And at the end of the day, the boys who got arrested, they were able to prove that they weren't even in the home at the time. They were at like an ATM on camera taking money out. And Nifong, the DA we keep referring to, it sounded like, as I understand it, the motive was that it was an election year, and he wanted to be really tough on this case because he thought it would get him a lot of votes in the upcoming election. If I'm correct, I believe he lost his bar license and did some jail time for that. So
as he should.
As he should.
He was going to consign innocent people to jail. Now, a smile comes to my face because I'm in the company of two excellent criminal defense attorneys. And Guy, as you noted, there was some excellent lawyering in that case, including getting the surveillance footage from the ATM, which gave one of the defendants an alibi, and some excellent work back then in the evolving field of DNA. But for the fact that, as you mentioned, the individual defendants had supportive family with financial resources, defending that case was beyond the ken of most capable defense attorneys, and that's what it took. Just to go back, this to me is editorializing, but if a prosecutor supposedly has the ethical duty of doing justice and bringing cases that have merit, when they intentionally abuse the powers they have, I don't see a justification for not holding them civilly liable. They knew what they were doing was wrong. It's one thing, well, a witness lied and I couldn't catch the perjury. But what Nifong did and what I read in other cases, planting evidence, withholding evidence, and it results in somebody going to jail and not receiving a fair trial, I think that's horrific.
Right. It's
Yeah.
complete
I
conflict
want
with
to
our
ask
concept.
one more. I don't know. Do we have enough time?
Well, we're about to wrap it up, which, by the way, I think this has been the best episode. As I started it by saying we've only had clients as guests, so this is the beginning of a 4-part series where we have non-client guests. And what a way to kick off this 4-part series, Oscar! I'm so excited that you've been here. So as we wrap it up, Mark, why don't you, bring up what you were going to ask, and then maybe Oscar has some
a quick
final.
question, because we've been focusing on excessive force, but you mentioned at the beginning that another area is false arrest. And I think a lot of people, would you agree, think false arrest is something where police arrest someone and ultimately they're not guilty of the crime, and that means that the police acted unreasonably by arresting. But that's not the case. correct? A question of whether or not there's probable cause to arrest, even if the person goes to trial is ultimately found not guilty, or the prosecutor decides to dismiss it, or the judge dismisses it. The standard of probable cause is much lower than guilt beyond a reasonable doubt. So it sounds to me, and I'm anxious to hear your experience, that it's probably a lot tougher to make a case of false arrest than one might think.
Certainly, and you've put your finger on it. Probable cause is what is known, or my argument should be known, to the reasonable officer at the time the decision to detain or arrest, I don't want to use the word detain, at the time the decision to arrest is made. And there's a bunch of cases that say whatever happens in court is not necessarily determinative of what somebody could or should do regarding the arrest. As you've noted, Mark, the standard for conviction beyond a reasonable doubt is much different than the standard for the arrest probable cause. So when I'm evaluating a case, I just look at anything that happened, there's a slight exaggeration, from the beginning of time up to the moment the officer says you're under arrest, or oftentimes they don't say you're under arrest, you just see the cuffs or the physical force being exerted. And there are numerous cases, and I've unfortunately been on the losing end where my client gets acquitted. We sue for false arrest, and there was enough evidence there to constitute probable cause that the case is lost.
Amazing.
So,
Interesting.
final question, just an example. Very early in my career, I got hired by a family. The defendant was in jail. The situation was that there was an armed robbery of a victim by two people. The victim's description at the time was one was 6'2", the other was 6'4". They both were under 200 pounds. That's what's in the police report. My client was at some hubcap, place where they, you buy these old hubcaps. And I guess the victim was there. The victim sees him, calls the police come, and the victim points my client out and says, "He's the one who robbed me. I'm absolutely certain." Police say, "Are you sure?" "Absolutely certain." Well, my client was 5'8" and 220 pounds. The police did not bother to look at the original police report. My client was arrested, was in jail for a while till I got hired. We ultimately got the case dropped. Would that be a false arrest?
So you raise an interesting point, mistaken identification. The way I understand the case law, and I'll use me as an example, whatever I am, 5'9", X amount of pounds, you see my ethnicity. So if a bystander gets a slight a slight physical characteristic wrong and the police acts on it, probably the police is going to be immune from liability. But if there's a complete mismatch, I don't know, let's see, I think most people know Shaquille O'Neal. So if I'm robbing a liquor store and the description is given of me, what I'd look like, Shaquille O'Neal is not a viable suspect. We just look different. And I also have the same thing involved in pursuits where a car is mistaken. I had a police officer on the stand tell me he shouldn't be required to know the difference between a two-door Mercedes and a four-door Mercedes. So it all depends on the mismatch between the subject at hand and what the ultimate arrestee looked like.
Well, Oscar, we thank you. If we had hours, we could probably continue going and going. You're certainly experienced, knowledgeable, and a great guest.
Thank you.
And but I think we're out of time, guys. Is that
Yeah.
correct?
We
I
are.
talked too much, sorry.
No, you don't. It was great. I
You did a
think
great
that,
job. We really appreciate it.
look, with our over 200,000 listeners, we don't know the demographics, but I'm sure there's a lot of lawyers out there, and I'm sure, there's a lot of individuals who they or their loved ones have been in trouble before. And I just want to say to them that clearly they can tell from today's episode that you are an expert in this field. And if they ever have a question or concern about abuse of force, false arrests, etc., government misconduct, that they need to reach out to you. So keep, everyone listening, write down Oscar Seiger's name and don't hesitate to call him if you think you have a cause of action, and he'll evaluate it for you. And without further ado, Mark, I think we'll tune out for now
and say to our listeners, you're
free to go.
Thank you.
Down Low Investigations is a sponsor of You're Free to Go. Behind every great criminal defense attorney is a great private investigator. That's why Mark and I use Down Low to investigate cases all over the country. Down Low can help you too, whether you're running a background check on an employee or running a background check on a blind date, or let's say you need someone followed or some other type of investigative work conducted. Down Low is the way to go. Call Download Investigations at 561-843-1806. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fromston and Mark Nurek and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.